Salon, 7 Bravo Street, St. Anne's Bay, St. Anne. Call them at 876-335-7427. The time My Finesse Beauty Salon is... The time is 7:30. This is Called Out Gospel Radio. Join attorney at law Gloria Brown for land matters every Tuesday at 7:30 p.m. Jamaica time, right here on COGR. Stay tuned and be blessed. Attorney Gloria Brown, it's always a blessing to have you. It's over to you. God bless.
Thank you so much. And it is indeed a blessing and a pleasure to be back with you and to our listeners on Called Out Gospel Radio for another program, Land Matters. Please remember, listeners, we invite you to share with us on any land-related matter. Buying land, selling land, getting a title for your land, anything in relation to land. We invite you to send a text message or WhatsApp message to 876-868-5109. That's 868-5109 or 535-8186. Or you can post your questions on the YouTube channel for Call Out Gospel Radio. And remember that Call Out Gospel Radio is located in Ucherio, St. Anne, and it's a station with the aim of making a difference. The aim of the station is to impact the lives of Jamaicans and all over the world, because we know that the airwaves are now not limited to time and space. So we are impacting the lives positively of persons all over the world, and we welcome you again and thank you for joining us via the radio stream or the app in the Google Play Store or on the YouTube channel, Call Out Gospel Radio, making a difference. So please send me your text messages or your WhatsApp messages to 876-868-5109 or 876-535 anything land related. Please send your messages so we can assist as best we can. I want to deal with a message that I did not deal with from last week, where someone sent this message, and it came a little after 8 o'clock when I had finished.
This is Called Out Gospel.
And the question was, should the executor sell land before probate? What is probate and who is an executor? An executor is a person who is appointed by a testator. The testator is the person who has made a will. And the executor only has power and can only start accessing power when the person who has made the will, the testator, has died. So let me put it in layman's terms. So somebody has died and they have named another person or persons as executor or executors. The executors or executor, they have no right to act until they have got probate. Probate is an order from the court to giving the executor permission to act. The executor can act to some limited extent before probate because, for example, if the person should have assets that might suffer from, might be destroyed, suppose the person died leaving animals, etc., things that could, go to waste, then the executor has a right to preserve those things. But executor has no right to go and sell any property until the court has granted probate, because the court is the institution, the organization that gives the executors the right to act. Suppose the executor should go ahead and start selling, and before probate is granted, somebody comes up with another will. What would happen? When the executor has got this probate from court, even if another will should come, the executor is protected because the court gave the permission. You'd have to revoke that will that was there, and if there's another will, but if the executor has acted already, the executor will be protected. But note, executor has no power to act, no right to sell any land before probate. But executor has a right to sell after probate. Executor has power, which is why we always encourage persons to choose your executors carefully. Because when you appoint somebody as your executor and you die and that person has got probate, The executor can do anything that the testator could have done. We put it this way: the executor steps in the shoes of the person who has died. So anything the person could have done. So the person could have gone to the bank and draw money from their account, executor can do that. The person could sell their property, executor can do that. So even if you put that the property is not to be sold, you cannot fetter the feet of the executor. Executor has the right to sell. So thank you so much for that question. Executors can sell, but only after probate. So I'm going to tell persons out there, we in Jamaica, we have this habit where we just go and buy land, sell land, just buy. Oh, Mr. Brown son selling land. I'm going to buy a piece, or I'm abroad. Let me send money from my father to buy a piece of the land that Mr. Brown selling. It does not work like that, which is why a lot of us run into a lot of problems, and we have conflict. Because I got a message from someone today to say that a gentleman is selling her a piece of land. She lives abroad, but she has been told that the gentleman sold a piece of land to somebody before, and that person is now abroad, so the man is selling it again. And what I said to her is, get your lawyer to speak to the lawyer for the seller, because you need to protect yourself, because you could go and put up your mansion, etc., and then only to be told that it was sold already. And do not put up anything on any land until you have a title in your name. So if there's a title in your husband's name, do not go and put up a house on your husband's land, because it does not belong to you. Even though the Bible says the two become one, it does not work like that in terms of ownership of land. What is your husband's is your husband. What is yours in terms of law. So you can go and put up that house on your husband's land, and he goes and sells everything and the house is sold, or your wife's land. So be careful. The numbers to send your messages: 876-868-5109 or 876-535-8186. And please note that my name is Gloria Brown, and I operate out of Ocho Rios and as well as Kingston. In Ocho Rios, my office is in the Jamaica National Building, Shop 6. And in Kingston, we're in the Winchester Business Center, 15 Hope Road, that's near to Halfway Tree in Kingston, Suite 39, Winchester Business Center. And Shop 6 in Jamaica National Building in Ocho Rios. And you can send your messages to, please send your text messages, any question you have in relation to land ownership or estates, 876-868-5109 or 876-535-8186. Also, when you're buying land, and I want to talk to a little bit this even about buying land. When you're buying land, always get a valuation done, and when you're selling land, get a valuation done as well, because you don't want to go and sell your land for $10 million when the valuation is going to show that it's worth 15. And you don't want to go and buy a piece of land for 15 million when the valuation is going to show that it's worth 10. So when I'm dealing with my clients, what I do is that if I'm representing somebody who is buying, after I have negotiated with the other lawyer and we have agreed to the terms of the agreement, and the lawyer sends me the agreement for sale for my client to sign, it is at that stage that I ask my client to do a survey and evaluation. Sometimes the clients might say they don't want to do a valuation because it has been sold for example, 10 million, and they know it's worth more than that, or they are satisfied. Fine. But usually I insist that my clients do a survey. When I will not insist and force the client to do a valuation, I want them to do a survey, because we have so many problems in terms of breaches. You do the survey and it shows that a piece of the land inside the fence is on the neighbor's land, or the neighbor is on a piece of your land. And if there's a breach like that, then and you're borrowing money to buy, then the financial institution is not going to allow you to proceed when there is a breach. Or they would need an undertaking from the attorney to say they are going to fix the breach. And a lot of times when it's an encroachment, for example, the housing trust is not going to take an undertaking. They are going to want the breach to be fixed before they will deal with a situation like that. So always do a survey. So the survey and the valuation, those must be done and paid for by the buyer. And if the sale doesn't come through and the seller changes their mind, that's still your expense. You can't go to Mr. Brown and say, after I spend the money for my valuation, I spend the money for my survey, you change your mind and say you're not selling it again, because most time the agreements will cover that to say that any expense that you should incur will be your expense as a buyer, and you can't go back to the seller to say you need to pay for these. Most times the lawyers will cover those in the agreement to protect themselves, because remember, the agreement for sale is done by the lawyer for the seller. So they are the ones who have the power usually. Please remember to send me your WhatsApp messages to 876 868 5109 or 876 535 8186. 535 8186 or 868-5109. You can send a message via WhatsApp if you have any questions. So, having surveyed your property and done your valuation, and you're satisfied because you're buying for 20 million and the valuation shows that it's worth 21 million, so you're happy. You're walking away with $1 million already. So your lawyer will ask you now to sign the agreement. You have done your valuation, you have done your survey, we're happy. We're going to ask you now to sign the agreement and pay your deposit. Because even though you're borrowing money, most financial institutions will not pay 100%. They will want you to pay down something 10% usually, sometimes 5%. So for example, you're buying the property for 7 million, but you're qualified for $8 million at Housing Trust or whichever institution you're using. Then you're going to be paying down most times 5%. So you're buying it for 7 million, you might have to pay down $350,000. Because remember, the lawyer is going to need that deposit in order to pay the government their stamp duty and transfer tax. Because even though the transfer tax is not your expense, the transfer tax is the expense of the person who is selling. All these expenses are going to come out of the money that you are paying, because the person who is selling is not going to put forward any money. They are just going to get the balance after their expenses have been taken out. So the lawyer will need that deposit. So after you have paid the deposit and you have signed the agreement for sale, then the lawyer will give you a copy of a receipt to show you have paid, a copy of the signed agreement, because after you have signed, they're going to send it for the sellers to sign. And after both parties have now signed, then your lawyer will give you a copy of the signed agreement, the copy of the receipt showing you have paid the deposit. Your lawyer is going to also give you a copy of the title, evidence that the water has been paid up and that the property taxes have been paid up. When it comes to sales, you don't have to show that you have paid the electricity, because electricity doesn't run with land. Water and taxes, those run with the land, which means that no matter who the owner is, if those are owed, whoever is the owner is going to owe them, even if they bought the land with those owing. So every lawyer selling property will ensure that they have paid up the water and the property taxes. You can get your own contract for electricity, even though the previous owner did not pay theirs. It's for JPS to go and find that company, that person, and recover whatever is owing. You're listening to Cordo Gospel Radio, a radio station which operates outside of Ocherios, and you're listening to Land Matters. This program is aired every Tuesday at 7:30, and I'm your host, Gloria Brown. Remember that the aim of Cordo Gospel Radio, the station you're listening to now, is to impact the lives of persons positively. And welcome to all persons who are listening to us via radio stream, on the app in the Google Play Store, or on the YouTube channel. Please send your feedback and calls to participate. Send your feedback, or you may call Cordo Gospel Radio at 876-868-5109 or 876-535-8186. And remember that, as I said, I'm Gloria Brown with an office in Ocherios and an office in Kingston, ready, willing, and able to assist you to sort out your land matters. So now that you have got your water receipt, your property tax certificate to show taxes have been paid up, you have your copy of the title, your agreement for sale signed by the vendor and the purchaser, and you have your receipts to show that you have paid the deposit. it is time to go to the mortgage company. You're going to take with you also the valuation that you have done and the surveyor's identification report. And remember, if the property doesn't have a title, then the financial institution are not going to entertain you. They're not going to give you any money because they want a title, they want something to hold on to. If Mr. Brown have a son is selling out Mr. Brown land and selling piece here and there, then you're not going to be able to go to the bank and borrow money because you have to be sure Mr. Brown's son will have to show you that he has a title that he can transfer to you, for the portion that you are buying. So don't just take your money and give Mr. Brown's son. Remember, get your own lawyer when you are buying, regardless of how informal the situation might be. Even if you're buying from your own parents, get a lawyer to represent you. And make sure that the person who is selling is in a position to sell. Because a lot of times persons selling and even the persons will come to me to represent them when I say I can't encourage you to buy that because it's Mr. Brown's son who is selling. They're going to let me know that everybody in the community know that it's Mr. Brown's son who owned the land, and it doesn't work like that because a lot of us will never see a title in our lifetime for some of these problem matters that we have, got ourselves involved in. So if the person has a title and all of that, and you get a copy of the title as well, as I said earlier, to take to your financial institution. Also, you're going to need to take to your financial institution evidence of the purchase. Evidence that you can purchase the property. So you're going to take your pay slips. Sometimes they want four of the last pay slips. Or suppose you have your own business, they're going to need business records, etc. Because remember that these lending institutions, they're operating for profit. So they are not going to just because you have a nice face to say, hey, we'll lend you the money. They want to ensure that you will be able to pay back. So they're going to look at your financial record and look at your job security, how long you have been working in that job, which is why they want these pay slips. All of those things are going to be important to the lending institutions. And depending on your age, that will determine how long they lend you the money for. So if you're a young person, you might find you're able to get a 35-year mortgage, etc. And then after everything is in order, then the lending institution will ask the lawyer for the seller to send them all the title and the stamped transfer and anything else that they need. And then the property will be transferred to the buyer. Note that the property is transferred to the buyer before the money is paid out. So what the bank is going to do, they're going to say to the seller's lawyer, send us the title, send us the transfer, etc. And we undertake that when our clients, when the person is borrowing the purchaser, when the purchaser is entered on the title, then we give an undertaking that we will pay you the balance that is owing. And that is how it goes. That's how the sale is. And when everything is done and the monies have been paid over, then you'll get a letter of possession, a letter to JPS, a letter to NWC, and the property tax will be transferred to your name in due course. That will take a little while. If the person doesn't have a title, as I said, you need to be extra cautious because I could have a piece of land and sell it to 10 persons, the same piece of land, because there's no title. And when there's no title, there's not much accountability. So be careful. Don't just give persons your money because you have persons out there who, hey, I sold it to Mr. Brown and he didn't finish paying. So I'm going to sell it again. And it's much more complex than that if somebody has not finished paying. You're listening to Called Gospel Radio, and we welcome you, the Called Gospel Radio family, to another in the series of Land Matters with me, attorney Gloria Brown. Land Matters is aired on Called Gospel Radio every Tuesday at 7:30 p.m. It's a half an hour program from 7:30 to 8 p.m. And Called Gospel Radio, as we said, is located in Ocho Rios, St. Anne, Jamaica. And you can join us via the radio stream or the app in the Google Play Store or on the YouTube channel. Please send your questions, your comments to 876-868-5109 or 876-535-8186. The danger of buying land, like how I'm saying, you see Mr. Brown with a piece of land, 5 acres, and you want a quarter acre. If you see somebody with 5 acres of land and you're buying a quarter acre, It is not enough for the surveyor to just go and survey a quarter acre. No, the surveyor needs to survey the entire 5 acres and show your piece as a subset. Those of us used to do math. So you're going to show the 5 acre and show where your little piece falls out, it falls inside of the 5 acres. And then the surveyor has to apply to the municipal corporation. We used to call them the parish council. The surveyor has to apply to the parish council for permission to cut the land. And sometimes you just buy a house spot and the parish council says, no, that lot is too small, so they are not going to allow subdivision. And you have already bought it, you have already put up your house, and Mr. Brown don't have any more to sell because he has sold everything around you. So you run into problem, which is why we say do not enter into agreement to buy without your lawyer, because the parish council might not approve the sale to you. There's good news though, because there's a special law called the Special Provisions Act of 2005, where if you have bought the property in most parts of Jamaica, if you have bought the piece of land more than 7 years ago, then an application can be made for subdivision to be waived. Again, it's important that before you do that, you double check what the title is saying, because if the title says the land is not to be subdivided, you can't get that waiver. So listeners, don't just go and buy land and say, sell me a piece. Know that you have to do some due diligence to ensure that the parish council has given permission to cut. If you have bought it more than 7 years ago, you have bought it long time, you are just learning this, then we can always apply to the parish council for permission. You can also apply under the Special Provisions Act for the subdivision to be waived. Important for you to note that. You're listening to Colo Gospel Radio. My name is Gloria Brown. Please send me your messages at 876-868-5109 or 876-535-8186. And our aim is to educate, to empower, to let persons be more knowledgeable. Because a lot of times the information we have is very anecdotal. I hear it all the time where persons will just say things. Oh, I'm paying the taxes, so I own the land. Remember, paying taxes will not make you own land. That cannot make anybody own land. If you pay my taxes, you realize that I've stopped paying taxes and you pay my taxes for me every year for the next 50 years. Do you think you can come and claim my property? No. So when you are paying the taxes, make sure you know who is on your land. Because you have your piece of land, I am occupying it, I start farming it, etc. But you are paying the taxes every year and you are not seeing what is happening on your land. After 12 years, I can claim your land. So it's not enough to say I'm paying the taxes. You need to know what is happening on your property. So we're encouraging listeners out there to protect your property. Fence it, put up the no trespassing sign like what we see persons used to do, and don't just drive past it every now and then. You need to know what is happening behind those many trees that are at the front. A man could have a house around the back and then claim adverse possession against your property. So important also, and it's important as well when you are buying land, because sometimes a lot of persons have trouble, and they are trying to pass it on. So I have this piece of land and a man has been occupying it with a trailer on it or planting things on it for years, and I haven't been visiting the area, or has a little house on it, or has fenced it around and attaches to his or her piece. And I realize what is happening, so I'm going to try and find somebody to sell it to. Even if you sell it to somebody, the man who has the adverse claim could come and say, I already have a claim. So be careful, look at what you are buying. We have a principle in law that is called caveat emptor, let the buyer beware. Okay, in Jamaican term, we used to say you get what you pay for. Let the buyer beware. So beware when you are buying. And also, when we are buying property as well, we want to encourage persons. When we are selling property, we also encourage persons to do a title search to make sure the title is clean. And you can go to the titles office and do a title search. You can check on any title at the titles office. They're not going to say to you, I'm not going to let you see the title because the title is the Governor General's property or the Prime Minister's or the opposition property. No. A title is a public document. Anybody can get a copy. You don't even have to go into the title office these days. You can just go online to Eland Jamaica or NLA or the NLA website and use your credit card and pay the $1,000 if you don't know the title number, or $500 if you know the title number, and you can just download a copy and print it. So a title is a public document, so it's good to do a title search. Mr. Brown's son is selling land. I want to make sure that he knows that he's the owner, and when you go and look at it, it's in his grandmother's name. Doesn't have the right to sell. Doesn't have the right to sell. And we see all kind of persons coming to say, I'm the one who buried my mother, so I should be able to sell. No. The mother has willed it to me, so I should be able to sell. No. Probate has to be done and your name entered on the title before you can start selling. I'm the one paying the taxes, so I can sell. No. Paying taxes will not give you the right to sell property. Okay, none of that. I have a deed of gift that was given to me. I would have to see the deed of gift, and I never allow my clients to buy. Suppose the property doesn't have a title. I need to see a survey diagram, and I need to see the document that the person who is selling my client to has. Suppose the person who is selling my client has a common law title or a deed of gift. Then I look at it and look at the age and do some due diligence. Because the danger of that, is that even when you have the common law title and it is recorded in the Island Records Office, I could sell that same piece of land to 100 people and the 100 deeds recorded, because when the Island Records Office recording deeds, they don't check to see if there's a deed already. It's not like the titles office that has the obligation to check if there's a title already. When the records office is recording, they record anything that they get. So we go in with 100 deeds for the same property, they will take the fee and record, because they only record, they do not do title searches. So it's important that you don't, even when the when the person who is selling has proper recorded deed, you still have to be careful. Remember I said, let the buyer beware. Remember, you're listening to Cordova Gospel Radio, and this is one of our newer radio stations operating outside of Ocherios, in Ocherios St. Anne, and you're listening to the program called Land Matters. And indeed, land does matter. And remember that you can always view this footage, listen to this, or view this footage on the YouTube page. But you can listen to Cordova Gospel Radio, and this is Land Matters is just one of the many offerings from this radio station. And the aim of the station is to impact the lives of persons positively. And don't we need positive impact in the Jamaica we now live in, where there are so many troubles, so many trials, so many of our children, our parents, our neighbors are grieving. Remember, it reminds me of when when Herod had given the order for the babies to be killed at the birth of Jesus. There's a verse that says, in Ramah was a voice heard, lamentation and weeping and great mourning. Rachel weeping for her children and would not be comforted because there are no more. And I think that is what is happening. You look at the parents of that UTEC girl, the parents of that 9-year-old, like Rachel weeping for her children and will not be comforted. But we thank God that He continues to be the God of all comfort and grace. And we ask that He will draw near to those among us who continue to grieve, especially those parents who are burying children, because I think that probably is one of the greatest grief, the greatest pain that persons can feel. Please remember, you can still send your messages, because we can address them next week at 876-868-5109, 876-535-8186. Since we have started this program, we have looked at intestacy, where a person dies without a will. We have looked at when a person dies testate, leaving a will. We have looked at tenancy, buying property, selling property, getting title for land. And I think that's the one that I'm getting most requests on. And I will review as well for persons. But remember, if you need me to get a title for you, just WhatsApp me the word title, and you're going to send that word to 876-387-3183. So if you want me to get a title for you, just WhatsApp me the word title to 876-387-3183. invite someone to listen to this program again. And I thank you so much for joining me again this week on Land Matters, and look forward to sharing with you next week, God willing. Have a good evening, Cordell Gospel Radio family.
And that was Land Matters with attorney at law Gloria Brown. Join her every Tuesday at 7:30 p.m. Jamaica time for this powerful and informative program right here on Called Out Gospel Radio COGR. Tune in and be informed, whether it's matters of buying, selling and subdivision of land, writing and probing will and testaments, acquiring and modifying land titles, and much more. As Land Matters, Tuesdays at 7:30, right here on Called Out Gospel Radio. The time by Called Out Gospel Radio, 1 minute after 8.